All right. So the time is 2:02. I'm calling the meeting of the Ad Hoc Committee to review County Board rules to order. A physical quorum of the members is not present. However, pursuant to Section 7E of the Open Meetings Act, members are permitted to attend remotely. Either one member of the committee, the chief administrative officer, or our legal counsel are physically present at the regular meeting location. In-person attendance and public comments are allowed, subject to the attendance limitations required to ensure health and safety of those who attend. Pursuant to the Illinois General Guidance to Public Bodies on the Open Meetings Act during the COVID-19 pandemic, dated July 2nd, 2020, county board members may participate without being physically present in compliance with the established provisions. Can we get a roll call, please?
Chaplin?
Here.
Desart?
Here.
Eckhoff?
Here.
Art?
Here.
Solomon?
Here.
Zay?
Here.
All right, great. Thank you, everyone. Next up is public comment. Do we have anyone in the room or anything submitted online?
No.
Okay. Only item under Chairwoman's remarks is I am hoping we can get through the rest of the rules today, but of course, if time doesn't allow for that, we'll keep going at our next meeting. But we're getting towards the tail end of this part of the agenda. So I just want to thank everyone again for making the time to be here. I have found these conversations to be really fruitful and productive, and I've appreciated the thought that everyone's given to this conversation. So I'm excited to get started today. Next up is approval of the minutes. We need a motion and a second, please.
So moved, Chaplin.
Second, Hart.
Okay, are there any comments, questions, discussion? All right, seeing none, roll call, please.
Chaplin?
Aye.
Desart?
Aye.
Eckhoff?
Aye.
Art?
Aye.
Solomon?
Aye.
Zay?
Aye.
All right, those are approved. Thank you. All right, so we move on to the next order of business, which is discussion. Going back to our rules packet, we left off last time at the bottom of page 26. It's section 6, ad hoc committees and special advisory groups. Part of the conversation that we had last time that sort of bled was a discussion of a focus on the arts. So I know there's some ongoing conversations about a current ad hoc for that. I also had notes that we were considering whether or not to wrap HR into finance or technology, maybe turning technology more into a shared services item. But let's go ahead and continue on from there. If anyone has any comments for under A, ad hoc committees. Member Desart?
Thank you, Chairwoman. I just had a suggestion that under ad hoc committees, this is the chairman of the county board may establish an ad hoc committee, and under number 1. And I was wondering, just to open the conversation, should we also add in there that a group of board members, say 6, which is how many it takes to get something on the agenda, can also form an ad hoc committee with the approval of the board?
Sure, I think that's worth considering. Does anyone have any other comments or thoughts on that item?
I like that idea. I second that motion.
Well, I do have a question. I mean, we have board members who are chairmen of committees. If they have something that they want to do, they can always do a subcommittee of their committee. I mean, I thought one of our goals was not to establish more committees, but it seems like we're establishing more committees than we start out on.
Okay.
That's my only question. I mean, it doesn't matter to me either way. It just seems like, all of a sudden 6 board members, and then who's going to appoint that then? The chairman has to appoint? Or would there be board members that appoint?
It would be the board members of that petition. I'm just kidding.
Wow.
Oh no, well, it's something to consider. Let's put it in our little, because I know, Jim, I totally agree. We're supposed to be, we don't want more committees. We want to consolidate committees, but that might be just something to consider. I think it's a worthwhile thing. So maybe we put it in our pack, for next week going forward when we finally get down to what we're going to put in and what we're going to put out,
Okay.
And, as against your argument, Member Zay, is that, you know, for example, I'm the chair of the legislative committee. What if I thought something like, I don't know, looking at the fine arts in DuPage County was something that I wanted to, that was important enough to have an ad hoc committee about. It's not under the legislative umbrella at all. So it's not like I could start a subcommittee by, you know, in my purview. Just a thought.
Right. Sorry, I just brought up at the last meeting on item B where it says other advisory bodies. It says the chairman may create special advisory groups. I think that's where you could put the chairman or 6 county board members. Majority of county board members can form special advisory groups. And I understand the arts and I support it, but who do we have on our staff that is fluent in the arts? You know what I mean? I think by a special advisory group, you can bring people in from the outside that actually has expertise in the arts, and you can put a couple board members, 3 board members, whatever you feel, and then you could finish that committee off or that special advisory group off with people from the arts that actually have the expertise. I just don't think sometimes our staff, I mean, they're all good, but I'm not sure who has the expertise in the arts, you know, at the county.
So one thing I think, so it seems like there is definitely appetite for another mechanism to create either an ad hoc or an advisory body. One thing I think we should continue discussing is whether it's how many people it takes to get that action. So do we think 6, the way we would do it, like to get something on an agenda, 6 signatures, or
I think,
members say, as you had said for the other advisory members, I had noted that you had said, or a majority of the board, so that would be 10.
if I can jump in,
Yes, Member Eckhoff and then Member Hart.
I don't know if our state's attorney is here, but there's already a provision that you can put it on the agenda with 6 signatures.
Right.
Maybe in a different part of the rules, but I think it governs this part of the rules. So I mean, you can put it in again if you want, but I think there's already a mechanism for you to put it on the agenda if for some reason the chairman wouldn't do it.
Correct.
So then, Nick, do you think this would be duplicative?
It would be redundant.
Okay. Member Hart?
Yeah, I think that just answered my comment, but if we were to have some mechanism like we already have about getting 6 signatures, whether it be a resolution or an ad hoc committee, I do think even if it's not statutorily required that it would be approved by the whole county board before it's established. But I think we just talked about that. So thank you.
Okay, so what I think I'm hearing for next steps is for A and B, we'll clarify that it's either the chairman or the board's normal mechanism of requiring 6 signatures, just to make it clear that board members can also bring this business if for some reason the chairman didn't want to. All right, any more comments on that section, A and B there? Okay. Next section is section 7, meeting procedures. Does anyone have anything on section A, meeting agendas? Yeah, members A.
Sure. Yeah, I mean, are we going to discuss public comment here? I mean, where's the right place to?
I had wanted to do that when we get to section D for words, but yes, I want to do public comment focus, but just when we get to section D, is that all right?
Okay, no, it's fine. Just want to make sure. Thank you.
All right, if nothing else in section A there, section B, let's do B and C if there's any comments anyone had noted for those items. All right, I don't see any.
Wait. Oh, I'm sorry, Member Chaplin.
Yep, please.
Okay, so I think, let me look at this because I was going through these. A member called on, okay, this fine. This part is fine. Okay, continue on, sorry.
No problem.
I didn't want to miss it.
Yeah, no, that's okay. All right, so let's switch to focusing solely on public comment. And before we get here, I want to sort of frame the way I've been thinking about this. And then of course I want everyone's input. So I think we need to sort of have 2 conversations. One is we've kind of agreed we're not going to change the meat of these rules until 2022. So I feel like we need to agree on what we think the current plan for public comment should be. And then I want to think about the ideal state of what public comments should look like. And that would be the rules that are part of the 2022 change. Does that make sense?
Wait, oh,
Yeah, sure.
Remember, thank you, Chair Salmon. So just wait, so just going back 1 second. So public comment, I thought some of these things we were going to change like immediately, like public comment, you know, like, well, maybe within a couple months. So are we going to, is that going to take place? Are we going to do it with like public comment and a couple of these other things, right? Everything else.
Right, that's what I'm
back
saying.
2 years. Okay, great. Okay,
Exactly,
just want to
yeah.
clarify that.
Because I think this is
Not-
yeah,
Yeah,
no,
not 2
this
years
is an
of this.
item, exactly, that has come up so much. I want to make sure we're really putting our heads together and dealing with it in a thoughtful way, not sort of, we had to do it by the seat of our pants in the last few months with the increase of public comment. So let's spend the time now to figure out what we should do in the short term, and we can make that suggestion to the full board ahead of the larger changes we want to make. Member Chaplin.
Okay, thank you. I just have a procedural question, and I don't know if maybe staff can answer this. I know some of the municipalities are allowing public comment to be made, but they're doing it like they're giving them access to the Zoom link, and then they come on and give their couple minutes via the Zoom link, which in a way might prevent, because you know, like they said, at 2 o'clock in the morning when you're angry, it's easy to shoot off a public comment, you know, and not read it yourself. But if people are, if we can maybe give them access to the Zoom link and they could make public comment, you know, kind of similar to how they do it when they're in person, and then leave it up to the, you know, 30 minutes of, you know, that's how we're going to do it. And then others, we would just, they could leave their comment, we'd make it part of the public record. I don't know if that would be too complicated, but I do think there's a huge issue with people, you know, being just angry and shooting these things off and maybe not even using their real name, or, you know, it's a lot different when you have to come in and speak than when you do it, you know, online. So those are some of my thoughts. I don't know.
Okay, so I think we could definitely ask IT, because I think that would just sort of be a different permissions mechanism. So I'd want to see how much work that would be. I would imagine.
Chair Selman,
Yeah, Jason.
we actually have Wendy Wagner in here, and I think she can speak to the technical question of that if you may.
Oh, great. Yeah.
So there's 2 issues as I see it. One is the security issue of basically putting a Zoom link public. That's how your meetings get hijacked, and that's how you have the Zoom bombing happen. Secondly, we only have licensing for 100 participants in a Zoom meeting. So if you make that public, you're going to have issues with county board members and other people joining if you have a lot of public comment.
All right, thank you. I think that's really helpful.
Thanks, Wendy.
Is any, yep, Member Desart?
Thank you, Madam Chair. I had a couple of thoughts on this section. One is under number 1, transparency. I would like to propose that even after COVID's over and we resume our in-person meetings, that we add that electronic offering. We keep that electronic offering as well, just so that people can reach out who may work during the day or can't attend a meeting in person. I'd like to see that we add the electronic offering. Under number 2, remarks confined to topics or activities which fall within the statutory authority of the county board. We've not been doing that. And one of the things I appreciate about this discussion of rules is we either have rules and enforce them, or we take the rule out. And what I'm thinking about specifically under this number 2 is that all of those comments we heard about opening schools that we have no authority to do. It's up to the superintendent and the school boards to make those decisions. So either we keep the rules in and enforce them, or we take the rule out.
So for that item, how would you envision enforcement? Like, would you want the public commenter to tell us the topic, or have to tie it to an item on the agenda? Because I hear what you're saying. The fear that I have is sort of the knowledge required to then participate. Like, we can all figure out on the agenda where the exact item is, but if someone just wants to write in about, you know, maybe they're just concerned about the care center, they may not know, oh, that's Health and Human Services and they meet this day. So did you have any thoughts on that, or do you want us to maybe research for now?
No, I do have thoughts on that. As I recall, the in-person forms have the item that you'd like to be talking about, like zoning or chickens or whatever the topic is. I recall that on that sheet, you have to write the topic that you want to discuss. So the state's attorney can weed out comments that aren't directly under the board authority. And then the electronic submissions are easy to weed out when they don't have anything to do with board business.
Okay. I guess I don't know if I've seen one of the in-person public comment forms, but that's just good to know. Member Hart?
Yeah, Member Sard, I completely agree with wanting to keep the electronic mechanism. I think that makes our meetings more accessible even to people not able to be here. Member Sullivan, my question is more for the state's attorney. I don't know if we have one in the room there, do we?
Yep, Nick is there with us.
Okay, so are we able, I mean, I know we have number, D2 on the books here, but are we able to even determine what a member of the public is coming before us to discuss? Are we able to police that, so to speak? I imagine it's somewhat of a slippery slope, and I agree we want our meeting time focused on issues that are germane to the board business, but it seems to me like we might not even be able to enforce that for First Amendment reasons, but I could be wrong, so wanted to ask a lawyer.
So you may limit public comment to the extent that it furthers the purposes of the board. So for instance, you could limit comment to the extent that it's only that which is relevant to the proceedings before the board that day. And that furthers the purpose of the board in that it'll help the board more readily be able to do its business. You see what I'm saying? So you can put limits on public comments and they will be legally upholdable if they further the purposes of the board.
Okay, thank you.
Member Chaplin? Oh, I'm sorry, Member Hart, please continue.
No, I was going to say, well, I was going to say in that case, I'm not sure what the solution is, but I'd favor some mechanism for us to make sure we're keeping board business on track. So whether that's what Member Desart proposed or something else, I'd favor that.
All right, thank you. Member Chaplin?
Yeah, no, I agree. And I was thinking, did we want to do public comment that's related to board business that day at the beginning of the meeting, and then general public comment, before new or old business? That way we can get our business done, and people that are waiting for their zoning to be passed, that are watching or whatever, or in the audience, can leave then and then wait for all the other general public comment. I know that's how school boards do it, or if we just want to keep it all under one. But I really think if we're going to do this, we really need to stick to our 30 minutes of in person and maybe 30 minutes online, and that's it. And that's our public comment. And I think that's pretty generous. And we probably really need to stick to that 3 minute per person as well. So, I think these are good rules if we just adhere to them. So.
Okay.
Yeah,
Sorry, I didn't know who was talking, but please go
This
ahead.
is Nick Alfonso. So if you want to implement a blanket relevancy requirement, that would require a change to the rules themselves to note that. If you wanted to implement that kind of, we'll do relevant comments first and then all comments at the end, that likely wouldn't require a blanket change or an actual change to the rule itself.
Okay.
That would just be a difference in the way that you're doing it that day.
Okay, and then Member Zay?
Yeah, thank you. There's a couple of things that bother me. The one thing that bothers me is the residency and the name and an address. I mean, we could have anybody in the world. You could have somebody put 10 different comments in, Joe Q Public at 123 Main Street. I mean, there's got to be some kind of requirement, just for the board's protection. And I mean, just for our protection. I mean, it's kind of strange that we can't, ask, people to have their residence and that, we have to check that, I mean, it's just kind of bizarre. I mean, anybody can send anything in, and I'm fine with that. The one section where, it has to be, germane to what we're discussing, but I mean, there's always a devil's advocate. I mean, we have county board members that are on the Board of Health. You brought up the schools. I mean, we do appoint members to the Board of Health. I mean, how do we make a determination on that it's not germane? They're asking for help with the Board of Health. We appoint the Board of Health. We have board members that serve on the Board of Health. It's just, we just have to make sure that we work with the state's attorney and we, make sure that, like you said, if it's germane to items that are on the agenda that day, I have no problem. And then if there's items that are not on the agenda that day, and put it later in the meeting, I'm fine with that, but we just have to make that determination. You know, maybe it's using, what's on the agenda that day and what's not on the agenda. Like, obviously, we don't deal with schools or anything like that, so it wouldn't be germane to that on the agenda that day. And like I said, you can put it, back farther in the public comment later in the meeting, after, old and new business.
So I think we've determined that we are interested at least in having some way to filter remarks, however they're received, whether it's someone there in person or on the electronic form, between board business on that agenda and then public comment later in the day at the end of, I think Member Chaplin said, before old and new business for the rest of the items. So our next steps there then are to research, maybe I guess while our peers do that, just to see if they have some other ideas as well. And to ask the clerk's office if there would be any complications to how they track things. I just want to make sure we're not like blowing up the entire way they track public comment. And then I had sort of a list of questions that have come up in our various discussions related to this issue. So I kind of want to just go through those. At some of our recent meetings, we've noticed who reads the comments at county board sort of changes around. I think it makes sense to have one person whose duty that is. I don't necessarily have a preference about whether that's someone from the state's attorney's office or someone from the clerk's office, but I do think it makes sense to be a staff member, just to take some sort of, I guess, any fears that there would be a partisan slant to it. But I want to hear the rest of the committee's thoughts. Member Chaplin?
Yeah, thanks so much. So I know that having maybe an elected official or like the clerk's office read some, especially if they're negative or positive towards that clerk, it's kind of awkward for them to read, for Deputy Clerk Johnson to read comments that might be either very positive or very negative about them. And it would be like us reading a comment about the county board. So maybe putting that off to like a staff member, maybe somebody from the county board staff or something, because I can understand where, or if it's a state's attorney and they're talking about the state's attorney's office and they have to read something, or glowing about the state's attorney or negative about the state's attorney. So it's kind of weird if you're, and those are just my thoughts on that, but.
Member Zay?
I think we should do it by seniority or alphabetically. That's what I think.
From Z to A, you mean?
No, from the other way around.
Does anyone object to it being a staff member before I go to the staff in the room? Because I know you may have thoughts. Okay, so maybe what we can ask is that senior staff maybe give this some thought and see, because I'm thinking it's either someone in the board office or maybe possibly someone in IT who has like a good radio voice, I don't know. But I think a suggestion from staff about who makes the most sense to ask them to take on that role and an estimation of how much time that is. So we can see, like, is this a large addition to someone's job, or is it, I want to size it to make sure we're not adding something to someone's role that really hampers their ability to do their day job. Is that all right in the room?
Only if we had somebody that was formerly in media that's got a good voice that could talk.
Member Desart, you had a comment?
Member Desart, perfect.
With your good radio voice?
Member Sullivan.
I will read them all. If we have a staff person now reading the comments, could we assign the assistant state's attorney in the room to actually time the comments and cut it off at 3 minutes?
So I think that's part of the conversation about who should do that. And I think we should consider that, because you've, I think, said in past meetings that school boards have had a timing mechanism and a mic cut. The mic cut makes me think it would belong in IT, but I would want tech to tell us maybe why that's a terrible idea. But yeah, I agree that maybe we should think through what should be some timing and a way to actually enforce the 3 minutes. Member Chaplin?
Whole process, as I've said throughout this whole process, we either keep the rules and enforce them, or we just take those rules out.
Yeah.
And I don't think taking that particular rule out would help anybody, because then we'd have 4-hour board meetings regularly.
Member Chaplin?
Thank you, Chair Selman. So I think it's later on in the board rules, but there's, the board can appoint a parliamentarian, or, I might want to change, maybe talk about changing the rules to maybe allow the board to bring a parliamentarian in, maybe part-time, and then that way that parliamentarian might be able to keep the time, tell the person to cut off. And then that parliamentarian would keep the board on track with our meetings, making sure that we're making correct motions, our meetings are being run correctly, we're following our rules, and we're following Robert's rules and things like that. So, later on in this document, there talks about parliamentarians. So, that might be a way also to keep us in time if we, do end up getting a parliamentarian. I think it's very important that we do have a parliamentarian, but that's just my opinion. So thank you.
Any more comments on the timekeeping issue before I move on to my next item? Yeah, Member Say.
Yeah, I mean, while we have staff looking into it, maybe we should have a timing device with a light or something with the countdown on there. I mean, basically, for in person, and I know we've been getting a lot, online, but, with a flashing, with 25, we use it for committees too, with 25 seconds left, it starts flashing yellow or something. I mean, not like a siren, but something to get their attention. And then, at the 3, you say, hey, big buzzer goes off, and, that's.
You bring out the
book comes out and grabs you and drags you off. But no, I agree. Yeah, if we're either going to enforce it or not enforce it, that's what we have to do.
And then would our state's attorney, Nick, do you think there's any issue with putting a character limit on the public comment form?
I'd have to double check and look into that.
Okay, because if there's not, I wonder if we can figure out what's about 3 minutes of spoken speech in a word count and put a word count on the public comment form.
Yeah.
Whatever the time.
Or character count.
Yeah, exactly.
We can look.
Okay, because I think that would be the way to get the written in comments timed, and then we're looking into the text solutions to keeping the in-person ones timed. Another item I had to discuss about public comment is member expectations during public comment. That means us. So I've had a few people ask, are we supposed to keep our camera on? Is that a problem? My understanding, and Nick, do correct if I'm wrong, is that that ALMA requires the cameras to be on for voting. So we know when someone says I, that it's me saying I and not like my neighbor, right? And so that does not apply to public comment, but I wanted to see if we wanted to put an expectation in there. So Nick, am I right about that interpretation of OMA?
Legally, there's no requirement for the camera to be on during public comment. You're correct.
Okay. So does anyone have any comments they want to make on that? Yeah, Member Hart?
Yeah, Member Selman, I completely agree with the sentiment behind it. I do tend to think that I would lean against having a rule requiring cameras on. If we're all in person, some board members step out of the room at various times throughout the meeting. I kind of view the camera going black as the virtual equivalent of that. And if the public wants to take note of what board members are listening via camera, they have the ability to do that on the Zoom. So I'm kind of thinking that we not police it. It's encouraged but not policed. That's my preference.
Thank you. I see Member to start with comment.
I agree with Member Hart. I agree with the sentiment, but I don't think we should police each other. No.
Okay. Any other comments on this item? Okay. So then we have the enforcement. Okay, required fields on the public comment form. So that's come up. I think name and address need to be required. I think that's okay of us to ask because we would at least be able to see or hear the name of the person if it was an in-person comment. Does anyone have any other items besides name and address that they would want, or maybe at least town and state? I can understand someone not wanting to give their home address. Maybe we just ask for town. But let's just discuss this item. I see Member Say and then Member Desart.
Go
no,
ahead.
sorry. Member Desart.
Yeah, I think for sure we should keep the field that asks what their public comment is regarding.
Yep, add that. I think we maybe have to add, I guess, I don't know if I've seen that form, but yes, agree that we need to have, what is this, what is your comment related to? Maybe like kind of a subject line.
Yes.
Member Hart?
Yeah, agree with subject. I also agree with what you just said, Member Solomon. I would probably prefer that address is not in there. I think we should require town, but I think there's a lot of people, rightfully so, that would be uncomfortable submitting their address publicly.
And then for those who've, you know, I know there's been various people who've had worries about, well, we don't even know if this person lives here. Does town and name give you enough to feel like you know who's actually commenting? See, member to start and then member Chaplin.
I was just wondering if we should put phone number in there. So if it's an issue that staff say zoning, a staff member could reach out to the person later, contacting them about their issue. Should we add phone number as a optional field? Yes.
Yeah, I think that's a great idea. Yeah.
Solomon,
Yes, please.
We got one of the state's attorneys here, Lisa Smith. She has a comment to make on that.
Yeah, I was going to ask her for that.
We can put in the form all of those things that you're asking for, but we can't require it. So if they leave out their address, they leave out their phone number, we can't deny them the right to comment. There's been an attorney general opinion on this matter in regard to a Lamont case. And there's also been conversations that we've had with the public access counselor that have indicated they're looking at this similar to FOIA requests or FOIA information, things that would be deemed private, such as your address, phone number, personal email. Those things can't be required of the public in order to comment.
Okay, that's really good context. Thank you.
And maybe we add, would you like a little box that says, would you like staff to contact you? And then a phone number, optional phone number.
That certainly would be fine, yes. I'm just saying we can't require it. We can have it, all the information and ask for it, but we just can't require it.
Thank you.
Is there further comment?
So
Yeah, member Zay?
fingerprints out of the question?
I think so.
Okay.
An example.
All right, did anyone else have comments on what data we're going to ask for on the public forum or any other changes to the public forum?
Sure, Solomon.
Uh-huh.
Based
Please.
on our last conversation, I actually put a brief set of slides together that actually show it's most of the municipalities in DuPage County, kind of where they're at with if they have a time limit.
Yeah,
and
please.
or they're individual, if you care for me to share that real quick.
Yeah, I think that's great.
Give me 1 second to pull it up here. So this, I have it individually parsed out as well, but for entities that with total public comment rule, 23 of the agencies or 23 of the municipalities or government bodies don't have a limit on time. One has 15 minutes set aside for public comment and 9 have 30 minutes. We're included in that 9. And then the next is the individual speakers, how much they limit individuals. One has no limit imposed. One has 2 minutes imposed. 23 different of the agencies have 3 minutes. Then one has 5 minutes. Just so you have some context, and I'll send this out. But this is each individual government body. But I'll keep it on this one. Ooh, if it lets me.
Thank you. I think that's really interesting. And it's nice to know we're not totally out of the realm. We're like a good middle way. I think that's all the comments I had gathered about people's various questions about public comment over the past few weeks. Is there anything else about public comment that you've had some thought about? Yeah, Member Hart?
And I don't know the answer, but I know we've gotten into a couple instances in our board meetings over the last year about the order of public comments read, specifically as it relates to the electronic submissions. I'm not sure if anyone has any thoughts on that. You know, Member Start's earlier point, I mean, if they're grouped by topic, I think that would be the most ideal way to go about it and align it with what's, first on the agenda. However, I do also know that that will require some staff time to go through and read all of the public comments, especially when they're accepted up till 9 a.m. That could be difficult. But, that would be my first preference. Second being, the chronological time of their submission. I think that would be easier on staff, but just wanted to open it up for the group for thoughts.
Thank you. Member Chaplin, and then, or did someone in the staff room say something?
Yes, I'm sorry, this is Lisa Smith again. The guidance from the Attorney General is that they should be read in the order that they're received.
They shouldn't be reorganized by topic. That would be an issue.
Correct.
Okay. All right. So then I saw Member Chaplin and Member
Sorry
Desart.
about that.
Yeah, so
Thank you.
I was wondering if we could, because it seems like we have our public comment open for like ever. So like you can start making comments on Friday, Saturday, Sunday. So maybe can we narrow that time frame? Maybe that might help us not get 500 comments a day. I mean, I don't know if that's possible. Like you can submit comment like Monday, all day Monday through 7 or whatever it is, 8 on Tuesday, something like that. I don't know if that's.
You can limit.
Yeah, Lisa and Nick are both nodding their head that yes, there is ways we could limit the submission timeline.
And for right now, do we accept them pretty much from Friday when the agendas are up until 9 a.m. the day of the meeting?
My understanding is technically if I wanted to put one in for the next county board meeting, I could do it today up until 7 a.m. of the day of the board meeting.
And you just pick,
my understanding.
you pick which, so you're not like, I want to make a comment to county board. It's, I want to make a comment to county board on this day.
I believe
Okay.
that's the case. Oh, is it just say, okay, yeah, so it'll be
Just
for
the next
whatever
one.
the next meeting is. That'll be what it's submitted into.
Okay. Member Zay, did you have a comment?
Yeah, can we narrow it to like Saturday nights from midnight to, you know,
Sundays.
to 12:10, you know? No, you can't narrow it that narrowly?
Might be a little too much.
I guess my own thought was that cutting it off at midnight the night before seems reasonable so that staff isn't coming in the morning of a Tuesday trying to sort through things. That sounds awful. But if we go, we have Member Chaplin, Member Desart, and then Member Hart.
Okay, this might be a really silly question, but can we say like our queue is full at 100 comments or at 70 comments? I mean, no, we probably can't, right? Oh, no, because then we want to publish them in the minutes.
In the
Forget
packet.
that. Yeah, just forget that. Sorry.
No worries. It's all good conversation. Member Desart?
I had two comments about public comment. Number one, back to D1, where I suggested adding electronic offering permanently, even after COVID's over. And I didn't really hear feedback about that. So I want to make sure that I was heard on that issue. And number two, I would vote for the read in the order that they're received, because if we put them in categories, like say chickens in one category, a soccer field in another category, once we hit that 30-minute mark, if we do continue to cut public comment off at 30 minutes, what if we've only heard about the chickens and not the soccer field at all? So I would suggest we keep it read in the order that they're received. Thank you.
Thank you. And so your first point about keeping the public form available after, is everyone in agreement that yes, that's something we want to do to keep access? All right, cool. I agree. Member Hart, you were next.
Yeah, thank you, Member Solomon. Agree with what we just talked about. I know I may make a lot of my fellow members mad at this about saying this, but you know, even though I know there is oftentimes instances where our meetings are elongated, I do generally think we should be in the position where we're making it easier for our citizens to engage with their government versus harder, right? So if we've already decided that there's going to be a 30-minute in-person, 30-minute electronic for a total of an hour public comment, I don't see why we would need to cap when the submissions are made, with maybe the exception of the time that they're due by. I think we should be given, similar to voting, giving people as much time frame in advance of our meetings as possible for them to submit their comment and not making it more difficult. So for that reason, I'd probably be against any restrictions that we're putting on, with the one caveat of the time for staff to actually pull and print the comments.
Yeah, I think we probably agree there. I think, so for staff, I think we want to figure out, well, I guess one of my questions too is if we're going to be able to put the minutes into the packet, if we do a cutoff at midnight on Mondays, is it possible for staff to get us the submitted online public comments before the Tuesday meetings then? Like if they kind of queue up in a PDF to get emailed to us, Because to Member Desart's point, if we cut it off at 30 minutes, let's say we don't get to the zoning items, and then we have to vote on them, and we have no way of knowing that there was comment. So while we're considering whether or not to have a cutoff time, can we see also if staff is able to get us those documents before meetings so that we can kind of breeze through and make sure we're not missing anything before the meeting?
Sure, Selman, my current understanding of it is that Dana Mundell is usually pretty good about getting it into a PDF packet and sends it off to the clerk's office for minutes. However, I off the top of my head don't know how long that takes her or what that time frame is, but I can gladly ask her, and we can find out if that's something where we can send it. I would imagine that it's probably something that can be done, but we'll check on it.
Finance at 8, so.
Oh, that is true. She does finance at 8, so that it might not be as quick as we need if we keep it at that 7 a.m. mark we currently have, but it's something I can inquire about.
Okay, and then maybe see if we cut it off if it's 5 p.m. Monday or 9 o'clock or midnight Monday. If there's a time that we could cut it off that would make it possible for that to be done, then we can consider if that's a change we want to make.
Yeah, let's.
Yeah, I do want
let
Dana
me
to
talk
sleep,
with,
so yeah.
staff, and we'll go from there.
Perfect. All right, so if we go back to the beginning of our public comment discussion, and I want to be mindful of time here, so we're about 45 minutes in. Are there any parts of this conversation that we've just had that once we figure out what we want to, like what we agree to and where there's consensus, that we wouldn't want to enact pretty much immediately once we present it to the board and the board agrees? Or do we feel like the public comment part can be something we bring to the board pretty quickly and ask to say, let's implement this now to make our meetings run a little smoother?
I'd like to see it enacted immediately.
Okay. Does anyone have objection to that?
No, I agree.
I agree. And
Perfect.
maybe we put, have staff put a little notice out saying, these are our public comment rule, new advised rules. We're going to be sticking to these just for the matter of efficiency or something like that. But just so nobody is blindsided and they didn't understand, I think.
Yeah. So I think, Jason, when we have our check-in, let's talk about when the best time to bring that back is, because I think we could probably get the public comment part all consensus through this committee and to the board before we have the final package to give. And I think that would help us all and that we have some clarity around this part of the agenda.
Yeah, I can start redlining some public comment for us to talk about. That's not a problem.
Perfect. All right, so I think that is all of our items on public comment. Is there anything else anyone has? Because I know this is an item we've all been thinking about for weeks. Okay. Oh yeah, please.
I just want to let you guys know that I have found a good article and a couple Attorney General's opinions on public comments that'll give you guys all a nice background and just general legal understanding of what the requirements of the OMA are.
That's fantastic.
Okay.
Great, thank you. I think that's awesome follow-up. All right, so moving on to, we're back in the rules packet on page 29. E is consent items. Do we see any questions, comments, changes there? No? Okay. Next up is item F, debate. Does anyone have comments? Yeah, Member Desart?
Thank you, Madam Chair. F1, no member shall speak more than once on the same question except by consent of the chairman, and then for only 1 minute after the other members desiring to speak have done so. Again, this is a rule that we don't adhere to, so why have it in there? We should just take this rule out, in my opinion, or adhere to it. But I think that squelches lively, productive conversation. If we did adhere to this, that would squelch ideas, conversation, a good debate. So I say take this paragraph out.
Okay. Other comments on, let's just stick on item F1. Yep, Member Chaplin.
Yep, thank you, Chair Selman. So yeah, so I shared Member Desart's sentiments on this. Actually, I think 1, 2, and 3 all probably, we don't follow them at all. maybe just for debate, keep it respectful and on topic, or something like that. But I don't think we don't follow these rules by either order or length of time that we speak. So, maybe for the sake of shortening up the document a little bit and, not having things in there that we don't follow, just take those out. I don't know how the others feel about it, but.
Okay. The one item I feel like maybe, and our state's attorney can weigh in here, I feel like there's probably needs to be a rule that the chairman recognizes you to offer debate and comment, and just probably logistically we need that in there.
Yes, yes.
But is there anything else that the state's attorney sees in that section that you're like, oh no, things will turn into chaos if you guys cut that? Or if you need to look at it more, that's okay. I'm kind of putting you on the spot.
Take a closer look at it.
Okay. So is there, I kind of tend to agree with both of you. I think we don't follow those rules. So eliminating them probably is not, really number 4, I guess, is the only one we sort of follow, just more as a courtesy. So I wouldn't mind keeping that in there because I think it's, it's rooted in a good basis. Are there other comments? Yeah, Member Hart?
Yeah, I think that the last sentence in item number 1, the chairman of the committee whose report is under consideration shall have the right to open and close debate. I'm in favor of keeping that. So I would say if we strike the rest of it, if that's the consensus of this committee, I just say that we keep that one piece.
And then anything on 2 or 3 that strikes you as, before I go to members A? So I think that's a good catch. I think you're right.
I would actually be in favor of keeping number 2. I don't want to stifle debate, but I also think that if we can't make a point in 5 minutes of discussion, we might not be making it the best way possible. So, I don't have a problem with any of these rules. Frankly, I agree with Member Stark, either keep them or get rid of them. I'd probably prefer to keep them and enforce them, but if it's the will of the body to get rid of them, I'd say keep the committee piece, and I think having a 5-minute rule is comfortable for me.
All right, and then I think I saw, members say, do you have your hand up or were you just writing?
No, I did. I Member Hart had the same question I did about that last sentence in 1, about the chairman of the committee, opening and closing debate. I think that should be kept in there.
Okay, and then I think we kind of agree on 4 also that we would want to keep that. And then we had somewhere in here, it needs to specify that the chairman's the one calling on you to offer debate, but how much of that language the state's attorney is going to confirm. Member to start and then Member Eckhoff.
I just, on number 2, no member shall speak longer than 5 minutes at one time. I just don't think we have that problem on the board anymore. Member Healy's off the board. I don't think we have that.
Said in love, but yes. I think I agree with you that we could cut out some of the other timely, like time things in 1, 2, and 3, because I think we have a good culture on the board where we don't do that very much. But some of the specifics that we've come to a little bit of a consensus, I think is a good idea. Member Eckhoff?
Well, I think in number 1 that we only have to delete the words "then only for 1 minute."
Yep.
Because I think it's important that everybody get a chance to speak first, and then somebody can speak a second time.
Yes.
And I don't think we have to write it in, because I think a chairman, our current chairman, and hopefully all future chairmen will be fair to everybody. And if somebody speaks a second time, then everybody gets to speak a second time before somebody speaks a third time, and so on and so on. I think that's pretty much how it's gone, but the part for only 1 minute should probably come out.
Okay, so I think the consensus is we're going to take out the time limits on members in debate here. Our state's attorney is going to go ahead and review to make sure we're not stripping ourselves the ability to debate items by doing this. We'll keep item 4. We'll keep that the chairman of the committee open and close, and that the chair recognizes for round 1 and then round 2. And then state's attorney can help us just with some much more succinct language to get that all included. Is that all right?
That's fine.
All right. Any more items on debate? Okay, moving on to item 6, priority of business. I have just like a question mark. So maybe, remember to start, you want to go first?
Yeah, I don't want anything in here that we don't do. And so all questions related to the priority of business shall be decided by the chair without debate, subject to an appeal but there's no vehicle in here that tells anybody how to appeal that. I mean, I've never seen this item be an issue actually, but it's in our rules, so let's address it.
Yeah, does anyone have any comments for maybe a time when we would or we have used this? I'm kind of staring at you, Member Zay, because I know you've been here longer.
Well,
So go Member
just-
Zay and then Eckhoff, please.
Yeah, I think it's just when they say subject to appeal, so if the chairman rules on something, then the board can appeal his ruling, which is in our rules. But again, I've never seen anybody do this in 20 plus years, so I don't understand it either.
So maybe it should be something that comes out of our rules.
Member
Yeah.
Eckhoff?
First of all, I know Mr. Zale's a lot older than me, so everyone thinks he's been around a lot longer than me, but I've
Really
actually
younger than you.
2 years less. But anyway, I think back in the day when Chairman Scholstrom was there, I think we had a couple of appeals, ruling of the chair. But all of that's contained in the Robert's Rules of Order, which are made part of our rules. So it's not specifically set out there. You know, we don't want to reprint Robert's Rules of Orders in our rules, but everyone, at least when I started, had a little booklet of Robert's Rules of Order in the desk. So, you know, look it up if you think that it doesn't cover it. But I can't remember exactly what the issues were back in the day, but we have, I think we've used it a couple of times. But Ashley, I thought that the chairman and you sit down and sort of talk about what the agenda for the county board is going to be for the next week anyway. So there was some input by the vice chair prior to the agenda being published.
Yeah, we do have weekly meetings to just make sure there's massive disagreement about that. You'd see it resolved before then.
I mean, I guess if you and he had a disagreement, then he's the chairman. Somebody's got to pull the trigger and make a decision. But
yeah, and then someone could move to change it if it was pressing, I think.
we can move things around on the agenda, you know.
Yeah, which we've done, certainly.
Right.
So I think the consensus is, unless when the state's attorney is doing his review and sees that we need this for some reason, that this is duplicative to Robert's rules, then we can just cut this item. Is there any objection to that being our plan? Okay. All right, next section is section H, attendance by electronic means. I think the discussion is, you know, once we get to hopefully this late summer, early fall, when we live in a mostly post-COVID world, do we want to have a input on when someone is remote, or do we trust our colleagues enough to know their own schedules of when they need to be remote for any given reason versus in the county building? My opinion, and I know I've discussed this with Member Hart, that it makes it a lot easier for younger people in the beginning or middle stages of their career to have a little bit of flexibility. I think it's something almost everyone's going to be looking for in any sort of job they do. But I think it's worth discussion. So does anyone have any other thoughts about whether or not we should sort of codify the way we're doing things now, or if there should be some restrictions? I see Member Chaplin and Member Desart. You're on mute, Member Chaplin.
Sorry, guys. Thank you, Member Chairwoman Salmon. So my thoughts on this are probably, do we need to check with the state's attorney on this regarding our electronic participation? So I want to make sure that we're doing that correctly. But I don't know if board members need to be monitored. Maybe put like, you know, in up to 10, I don't know. I pretty much trust nobody will take advantage of it, but I don't know. It's up to the other board members. But I think we really need to talk with our state's attorney to see what the Open Meetings Act requires and if they allow for this now that we have the new technology. So.
Agreed. I think we should discuss sort of how we'd want it to work, and then the state's attorney will make sure that we're not inventing things that are illegal. I absolutely agree. Yes, please.
Before we go down a path, I think the state's attorney can make a comment about OMA, because I think we're going a direction that I think the act might not allow. So
okay.
I think Nick might have a point to this.
Yeah, so right now we're able to attend remotely due to the status of emergency and the emergency order. Once that emergency order is no longer in effect, You can only attend meetings remotely pursuant to OMA under very few exceptions, and that is, personal illness or disability, employment purposes or business of the public body, or a family or other emergency. So really, there's going to be a lot of limitations here as to, I mean, I know we have the technology, but OMA is going to require in-person attendance for the most part.
So can you clarify what the business or employment is? Because I feel like that's where it becomes incredibly open.
So the cases I've seen,
Military.
yeah, military service is one. Business of the public body, say that the public body has sent one of you to DC. You can attend remotely due to the fact that you're in the business of the public body for purposes of that meeting.
Another example that Cheryl just mentioned is NACO is an example of that. If you guys were at a NACO event or something like that.
So I guess my question is, you're saying OMA prevents if I'm out of town for a wedding, let's say, and I make sure I'm available on Tuesdays to still do my job. OMA says I can't actually do that.
Correct.
Yeah,
OMA
correct.
says that, yeah, you can. Sadly, that's the way the law is currently written.
Okay. Member Hart?
Yeah, again, I'm not an attorney, but so OMA did say for family emergency as well. Does it stipulate what a family emergency is? Similarly for employment reasons. I mean, the examples you just gave were related to our county jobs, but does OMA stipulate that it has to be for a public position employment conflict? My preference, Member Sullivan, to what you said before, if the answer to both those questions is no, I would say we mirror OMA in as vague terms as possible. I mean, like you said, if we want to increase the diversity of this board, if we want to increase the plausibility for successful and great candidates to run for political office at the county, I think we need to mirror what in many cases the private sector is doing. And if we're not under legal requirements to be more restrictive, I would suggest that we follow OMA to the extent we need to. But I think I interrupted our state's attorney if you wanted to comment on my question, but that's kind of my thoughts.
So going along the lines of the employment purposes generality that you just mentioned, that is as written. So it's general employment purposes. I would suggest that would mean, if you're stuck at work and because you're at your job, you cannot attend in person, then you should be able to remote in under those circumstances. Yes.
Okay.
I would just suggest so that going forward that we do mirror the Open Meetings Act. I mean, just so that way there's no way that we're trying to get around those terms or, but I think there is some possibility after this pandemic that some of those terms may as well change too, given the fact that so many people have been remote for this long.
Yep.
Thank you. Member Zay?
Yeah, I mean, I just want to make sure, I agree that, how we stipulate this. I mean, what's a health emergency? You have a child who's sick, a spouse who's sick, you're caring for an elderly parent who's sick. I mean, we just got to make sure we're following the rules on that, because I think there should be, exceptions to that where we can, if we're within OMA, we should be following that. And then, I think every board member will do I think we can trust them to make that decision. I mean, you're not going to see Grant in Hawaii sitting on a beach saying he's taking care of his cats or something. I mean, someone's going to figure that out.
Line.
But there should be some flexibility on that to for special circumstances.
Okay. And then can we also look and see what OMA requires for when you are participating electronically? I know I've made comment before about, sometimes there's someone who's driving or they're in another meeting, you hear other people talking while they're trying to speak. And I know we wouldn't allow our staff to do that. They would very much be told they can't work remotely then. Can we see if because I know, we know you have to be on video right now so that when you vote, it counts. Are there other items in OMA like that?
Not that I'm aware of.
No, not that we were aware of. The only other requirement of OMA is that you have to notify the recording secretary or clerk before the meeting, unless provided that notice is for some reason impractical.
Okay, so for right now, it's the emergency covers that we don't have to tell every secretary when we're remote, but once the emergency part of the OMA is lifted, we would need to tell our secretaries.
Correct.
So, Chair Sullivan, one other thing to that also is in traditional times, we don't have Zoom links doing this all the time either. So there is that logistical aspect of having IT be in if something were else to occur, just when we get back to normal times, whatever that might be.
Okay, so I think that sort of falls into this item 2 where to the extent possible 24-hour notice to tell either the committee clerk or the county clerk if you're going to be remote. So we could add something though, like you need to be alone or in a place where you can have quiet, you're not operating a vehicle while you're participating, or everyone can tell me that's just my pet peeve and I should shove off, that's also okay. But I think it's probably a good idea. But does anyone have other comment? Member Chaplin?
Yes, thank you, Chairwoman Salmon. Yes, I agree. I don't think people should be driving and participating in meetings. I don't know why I had to put that in the rules, but I think we might have to put it in the rules because it's not a good example. That's all. Bad governing.
Maybe we can just put something in about like board members are required to not have excessive noise and distractions that would interrupt board business. Some language that's a little more eloquent than that, but that's kind of the gist that we're getting at. Member Desart?
Yeah, I disagree. I don't think we police ourselves like that. I mean, I'm in a quiet office right now. Everything is very quiet and I'm focused on our conversation, but any second somebody could be shoveling outside and my dogs could go nuts. So then what would my punishment be for not maintaining a quiet atmosphere? I agree with you both that somebody driving in a vehicle is bad judgment, but I don't think we should police it by putting it in the board rules.
So I hear what you're saying. I guess what do we do then when it does affect our ability to do business? You know, there was a few weeks ago, someone was speaking, you could hear that their car door was open. So it was dinging the whole time they were talking and it was hard to hear what they were saying. And then it was hard for anyone else to start talking because there was all of, I guess I'm trying to find a solution so we don't have that happen because I don't care about the choices that person is making, but I care about our ability to, you know, get to our agenda and get our public business done. And I'm not saying I have a solution to that. I'm asking for ideas.
Yeah, I hear you. And I just say, call them out at the time. You know, just say, Zay, your car door is dinging, knock it off.
Hey.
It was not member Zay.
We all know it's Pete. I mean, he's got an Uber route. What are you gonna do?
All right. Does anyone have any more comments besides maybe it's just my pet peeve? That's okay. Member Eckhoff?
I attended a seminar yesterday about court appearances by Zoom. And the discussion about that is that it's still court. You're still supposed to have a certain decorum. I've been in Zoom meetings where all the participants are there and the judge will tell people, take off your hat, you know, and with the driving part, I think one of the judges made the person pull over and stop driving for at least safety purposes. So you sort of maybe have to rely on the chairman to police those type of things. But the point is, and you can maybe make a statement of it, that if you're going to participate via Zoom, you're supposed to maintain the dignity and the decorum that is present if you were there in person.
I think that's a good idea. Do you think language like that belongs in our rules, or do you think that that should just be something we all as elected adults can achieve?
I don't know if it has to, I don't know if you can really make it a rule because it's a judgment call when you see certain things, but it should be a statement of policy or something. Maybe,
Okay.
That means in the rules, but just in general. And then you have to have the chairman call them out on it if they're doing it. Just like if somebody started to use foul language at a meeting, you know, they'd be told that they are out of order. I mean, when Zoom started, we had attorneys showing up in bed and without shirts on. That was guys. I mean, so it was really ridiculous how casual it was. And people have really made an effort over the last year to say, hey, look, that's not right. You're in court. You know, you can be like, I'm at my house right now, but at least it's not something where it's some crazy situation or you're supposed to dress appropriately and things like that. So I think you can make it a statement of policy, and you can, because it's subjective, you're going to have to trust the chairman to enforce it.
All right. So I think unless anyone has other comments on this item, the only updates we're going to make to section H are making it just as lenient as OMA will allow when we're back to normal times. Is that the consensus, that we don't want anything that restricts past what OMA restricts? Okay. All right, next section is parliamentary rules. Oh,
before-
yeah,
To that, there's two sections of our meetings that's not under section 7,
okay,
and that's old business and new business. And, you know, I think there needs to be some type of a statement or something said that we're not, that old business and new business, just like the rest of the meeting, is not supposed to be politicized. And that we're not supposed to talk about our own campaigns. We're not supposed to talk about other people's campaigns. We're really not supposed to do any politicking at all. And it used to sort of be in our rules. And I think they got watered down a little bit because there was a concern about freedom of speech. But we shouldn't, you know, I shouldn't go on the board floor and say, hey, everybody remember, I've got a fundraiser this Friday at blah, blah, blah. I think there needs to be some statement, or I shouldn't be calling out somebody because, you know, they did something I didn't like politically. So if we don't have to write anything up today about it, but it's something that I've been thinking about, that I think we need to have some guidance that those areas are off limits when we get to old business and new business.
all right, Member Chaplin.
Oh, yeah, thank you. And thank you, Member Eckhoff. Because that does bring up a good point. You know, when we do have old business and new business, a lot of us talk about like events that are going on in our community or things like that. So maybe we have old business, new business, and then maybe we have elected official like report or something like that. If you have something that you want to announce, or announcements on there, we could skip right through old business and new business and do a announcement thing or something like that, you know, for, like I said, if you have an event going on in your district, or, you know, like Jim does the sustainable challenge with the high school kids, you know, there's a lot of recycle events with scares, things like that. Maybe we put that under announcements then instead of old, because it kind of gets mucked up with old and new business. What we talk about under old new business really a lot of times isn't old and new business. It's a lot of times announcements. So just a thought.
Do we have any further comments on this item? Does our state's attorney have any, do you have thoughts about why there's not specific rules about old or new business, or we can just add them if we want to?
No, we have really no opinion as to those issues.
Okay.
How about airing of grievances after that? No?
Only December meetings, that's it.
I'll look up the old language that we used to have and have staff shoot it out so you can take a look at it.
Okay, yeah, and then when, maybe staff, we can just sort of include that in our report that we're gonna look at for redlining and such, so that we can have the good context when we get to this section. Okay,
Good.
great, thank you. So section 8, parliamentary rules. So the first section, I know we've discussed other times, this says we have a parliamentarian who enforces these things, and we don't actually have that. I had asked staff if we could look into how other boards, if they have a parliamentarian, is it a full-time thing? Is it part of someone's job? What that pays, sort of thing. So I know we're going to be looking into that, but I know there's some other comments that people have on this item. Or maybe we've already covered it earlier. We were kind of just saying we need one. Yeah, Member Hart?
Yeah, I agree with the sentiment behind it, and I know we're doing more research. I just want to say for the record, you know, I'm not sure if spending more money to hire a parliamentarian is the right approach. I'm not sure if that's necessary, especially at a time when we're trying to conserve funds for obvious reasons. I mean, we've had the state's attorney do that in the past, at least since I've been on the board for 3 or so years, and I think it's worked fine, personally. And, you know, maybe the state's attorney would say that's not a job that role should be doing. I'd be all ears, but I just have some concerns about hiring for a role that, you know, can be done with our existing resources.
I kind of wonder, and then Member Chaplin, I see you next. I don't think this is a full-time role. I mean, I could be very wrong, but I sort of see this as part of that public comment policing. Like, we would pick a person who's the enforcer and this would be part of their job. And so I want to see, is it 5 hours a week? Is it 15 hours a week? That sort of thing. But I think I agree that a FTE is not the fit here. Member Chaplin.
Thank you, Chairman Selman. Yeah, the last couple meetings, we haven't really followed our rules or our, and when we asked the state's attorney, like I was calling for a point of order at the last meeting, and I was trying to point out something, and I got steamrolled by basically everybody there. But the point is, like, and I just realized this going through our rules when we were going through the rules for our rules committee, but when you do a motion to postpone, actually our rules say that ends discussion, but Robert's rules say you can discuss it. So, but our rules supersede Robert's rules. So I was trying to make it a point that, oh no, we already discussed this anyways last week. We shouldn't be discussing it because when you make a motion to postpone, our rules say that ends discussion. So that supersedes Robert rules, but our state's attorney didn't have us follow our own rules. So I do have some concerns that our meetings aren't necessarily being run or we're not following our rules, and maybe because our state's attorney is not a parliamentarian. And I do think to have good, fair meetings, we need a parliamentarian that understands our rules and Robert's rules. So, and it's happened more than once. So, but that's why I think it's really, it would really help our meetings run smooth. And, if that parliamentarian could even read the comments, maybe, take that off of the staff and anybody else. So, I think it's something to look into, or finding somebody at the county that understands our rules and Robert's rules and make sure that our meetings are run properly.
Thank you. Member Dessart? And then I see we'll have our state's attorney comment after that.
Thank you. And this is, a gentle conversation to have, but we have heard a lot of bad rulings from our state's attorney when we ask for a rules or a parliamentary piece of advice. We look back later in Robert's Rules of Order and our state's attorney is wrong. It's wrong. It's bad advice that we're being given. So I can see the value of both Member Hart and Member Chaplin's comments in that maybe there is somebody in the state's attorney's office, so we're not hiring somebody outside of DuPage County who is a better parliamentarian than the person who currently serves as parliamentarian. Does somebody know Robert's rules better than the ASA we currently use? Because he's not very good. Sorry, I said it.
So I think
Yeah,
please go ahead.
I am aware of, at last county board meeting, that one of the rules of the county board procedures was overlooked, and I'm aware of that, and that's going to be addressed at next week's meeting. But I think that to the degree that sometimes the county board rules do not address a certain matter, I think that Assistant State's Attorney McCarthy is very good at Robert's rules and tries to give the most accurate and best rules on the spot while he's there at the meeting. And to the degree of, our role is really to make sure that proper procedures are being followed with regard to the actions that are being taken by the board. And that's, our main purpose there. So as far as whether we don't view our job as to police a particular member, if they're, if they're following some type of, by what they're saying or what they're doing. Our guideline is to make sure that the actions being taken are taken appropriately. But I am aware of last week's, the actual county board rule did speak to the motion to postpone that Member Chaplin was referring to. And Assistant State's Attorney McCarthy will be addressing that next week.
So thank you so much for that. I think for follow-ups, what we want to do is, much like we're sort of right-sizing these enforcer rules for public comment, I think we want to right-size how much work and what expertise is required out of someone that would fulfill this parliamentary role, and then see if that can also be the same person who's doing our public comment and timing. And then that'll help us see, is this a 5 hours a week deal? Is this 20 hours a week? So we really need to shift someone's responsibilities around, or, so I think that's the work we need to do to figure out what decision we want to make. Members A?
Thank you, Madam Chair. You know, I just have to disagree on some of this. And I just think, you know, the state's attorney's not going to like this, but the state's attorney is there for advice and consent. We need to police ourselves. I mean, in the past, there was a reason why every county board member got a Robert's Rules, and a parliamentarian was selected amongst the board members, one among equals. And you have an outsider come in and tell me what to do. I don't have no responsibility or anything to listen to him. I will listen more to a board member than an outsider coming in and trying to tell me what to do. So I think we're putting a lot on this. Liz, I apologize. I didn't know anything about motion on table. If there's a problem where the state's attorney is wrong, then we have to appeal his ruling and say that, and just say, you know what, I'm appealing the ruling and it's in our rules in this section. And then, you know, then we have to go there. But I just think we got to start policing ourselves. And if we need to select a member amongst ourselves, it's a parliamentarian. I think we need to do that. By bringing outsiders in, it's just gonna, I mean, who are you gonna find as a parliamentarian who's not prejudiced on somebody else? I mean, it's just a difficult situation. And,
Yeah.
you know, I'd like to see, you know, just, it's hard, you know, we're bringing outside people in to read stuff. I mean, it just seems like it's getting bigger and bigger where, you know, I mean, how would you like to be that staff member that's got to read public comment? I mean,
I know, I want to, but hey,
I
you
think
know,
it's tough. That's things you have to think about, though. I mean, that's a lot of pressure on a staff member to do that, and as it would be a lot of pressure on somebody to be a parliamentarian.
sure. Well, if I may, our rules do say that, I believe it says shall, pick a parliamentarian from the board. So if we have somebody, if we can pick somebody from the board, that's fine too. I didn't know if anybody would want to do it or not, but because I think our rule, and that's another rule that we're not following, because it says we shall hire, pick among the board this parliamentarian. So, maybe we need to do that in whenever. 2022 or whenever we're going to do it, but just something I think that we should definitely have, because it's really not fair. The state's attorney is not the parliamentarian, but that's who we go to for advice. So kind of puts them in an awkward spot. So so if we want to pick somebody from our membership, I think that's fine as well too. But then that way we're following our rules.
Member Eckhoff?
I just wanted to jump in and say, I think the state's attorney's got a really tough job. I think Connor's done a good job. It's not always easy to get everything 100% right, especially when you have conflicting rules and you probably haven't touched on some of those for a long period of time. So if we want to get a parliamentarian, I'm just concerned that one side or the other is going to say that it's prejudicial or slanted towards one party or the other. That's sort of why I liked having the state's attorney's office doing most of that, because they're supposed to be, I understand the position of state's attorneys elected, but the staff people I don't think are necessarily political.
All right, so for next steps, if there's no other comments here, I think we're still researching to see what our peer counties do for their parliamentarian, in case they've come up with a really cost-effective, efficient way to do this. And if that's not the case, and they seem to all have their own members who they have someone elected as a parliamentarian out of their own body, maybe we can figure out what the structure around that is, because I don't want to just, pick out and say, okay, Jim Zay, now you're our parliamentarian, but not actually give, I know you don't want to. I don't think anyone actually wants to be the parliamentarian. And that's why I've suggested it be a staff person and get it out of any other office which has an elected head. But so we're still going to keep doing the research to see what our fellow members are doing. And we all have agreement that this role needs to be filled. We're just figuring out, is it a staff person? Are we designating it to the state's attorney's office? Or are we going to keep the rule that says it's a member within our body? Is there any more comments on the parliamentarian section? All right, seeing none. So the next section is section 9, special rules of procedure. Did anyone have anything for section A, appeals from decision of the chair? I'm seeing none. Okay. Item B is motion to amend. Are there comments about this section? All right, seeing none. In the room again, just holler if you guys have something. It's kind of hard to see hands all the time.
Yeah, can I remember?
Yeah, yes, please.
I'm sorry, I'd like to go back to the parliamentarian just to go
Sure.
under G,
Mhm.
the duties of members. I just think number 1 is antiquated and silly. I mean, I know most of us do it already. Mr. Madam Chairperson, Madam Chairwoman, and, you know, Chairman Cronin, we do that automatically. But I think that sometimes people don't. And so again, why should it be in our rule and guide if we don't always do it? I think it's antiquated.
Okay, I would think we maybe probably still need the part about the don't talk until you're recognized by the chair. But maybe we can just see what other language there is, because I agree that we don't need to specifically say you need to use the chairman's honorific. I think we all are appropriate and respectful enough to do so, or just, you know, Mr. Cronin or chairman or something. Member Chaplin, did you have comment? No? Okay. So if we could just check and have the state's attorney review that I'm sure some of that language needs to be there, but we can probably pull out the specific language about how to refer to the chairman. But I think that's a good point.
Thank you.
Okay, so we're on page 32, C, question of personal privilege. The only note I had here is that we commonly will say, well, so-and-so said my name. That's not actually what our rules say. It's just not that specific. It's a question of personal privilege in which, and here's a his, her that needs to be updated, in which their personal integrity, character, or motives are assailed, questioned, or impugned. I think that is generic enough. I don't think we actually want the rules to say I have to say Greg Hart's a jerk, right? Like, that's silly. Does anyone have any other comments about that before we move along? It drew my eye, so I want to make sure we had time to look. Okay. Sorry, member.
Chair Solomon.
Yes, please.
State's attorney also has a comment.
Just for your knowledge, the notion of calling another member by name is actually, Robert's rules specifically forbids that. So that's why.
Oh, that's right, because you're supposed to say like my colleague from, I don't know, I'm picking on Greg today, District 3 or something like that if you're actually, right?
Correct.
Okay. All right, if no other comments on item C there, let's just take D, E, and F together. Is there any comments, questions, amendments on those items? Okay, I think we're getting to the speedy part of our rules here. G, division of questions. This is something we do pretty often. Does anyone have any comments or amendments there? Okay. Next, H, motions to lay on the table or take from the table. Any comments or questions here? Okay, seeing none. Motion to postpone, anything under there? Okay. Motion to substitute. Anybody feel like they know our rules really well, not that they've gone through all of this the last couple of weeks? Reconsideration. Okay. Previous question or closing debate. Okay, motion to adjourn. Nothing, okay. Committee reports. All right, nothing. Precedence of motions. Any comments here? All right, last point of this section, point of order. Any comments or questions there? All right, we're so close. All right, section 10, actions of the county board. let's just do A and B together. Any comments on majority vote generally required or actions requiring an extraordinary vote, which go through the different amounts we need to get for different sorts of overrides and things like that. I imagine most of this is just statutorily, I mean, it's clearly statutorily required, so I figure there's probably not a lot of comment here. All right, on to item C, roll call voting. Nothing there, okay. D, policy ordinances.
I actually did have something.
Yeah, come on, what you got?
Under C2.
Mhm.
I think we all got elected to make decisions, and we should either vote yay or nay, and you shouldn't be allowed to abstain or vote present. That irritates me all the time. I mean, it happens very rarely, but you know, you didn't get elected to abstain. You didn't get elected just to vote present. So my preference would be to remove those two options.
I think we need abstain for conflicts of interest, to make sure people aren't, lining their own pockets. But present, I think, is some discussion for sure.
Well, I understand abstaining if you leave the room, you can't vote. But I think I've heard people say abstain when they're voting, not because they've got a conflict, but because they just don't want to vote. I think you should, if abstain means you can leave the room, then that's fine to leave it, but that's not how I think it's always.
Yeah, sit there and abstain. Okay. Member to start, and then maybe if our state's attorney has any items after member to start to add here.
I had a comment about number 7. The chairman shall announce the figures, ask if there is any objection by the members, and declare the result of the motion. And I know I sound like a broken record, but again, this is something that we don't do. So either we should start doing it or take this out.
Okay. I think we sort of like half the time do it. I wonder, could senior staff next time where they're talking with the chairman, talk about this specifically? Because I think he kind of does it stylistically sometimes and sometimes doesn't, but let's get his opinion and then if we'll keep it or not keep it. So I just want to make sure there's not something we're not thinking of, but good point, I think. Member Chaplin?
Yes, thanks. So going back to the abstain, kind of like driving in the car or whatever, I guess, maybe we don't want to police that. And if somebody abstains, I think they have their voters to, hold them accountable saying, hey, why did you abstain or vote present on these items? So that's all my comment. If people want to remove it, that's fine, but that's my comment on that. And then number 7, I understand what member to start saying, but for me, it is kind of helpful. I think we pretty much do that it says motion carries. I hear that a lot. Motion carry, all ayes or, everybody voted, motion carries. For me, it kind of helps go on to the next item. It's kind of like ending that one item on the agenda, going on to the other. And I think I think most committees do that, but if y'all want to take it out, that's fine. But just for me, I kind of think it's like a summary of that item. So I think it's kind of important for even people that are watching that they understand what just took place to do that.
Yeah, and I prefer that we left it in, Member Chaplin. I would prefer that we left it in, but then just have the chairman start doing this. And also, now that our meetings are via Zoom, it's hard for me to kind of hear and know what the vote is. Is it 18-0? Is it 9-9? I don't know. I can't hear or really follow the votes, especially on Zoom. So if the chairman did say motion passes 18-0, that would be helpful.
Okay, so we'll follow up with, like I said, having senior staff ask the chairman, because I could see him saying like, well, yeah, declare the result. That's easy, but I'm never going to remember to always ask if there's objections. So maybe we just edit it down, but I think that's a great point. Any more conversation on that item before we keep going here?
I did have a question on roll call voting. Maybe I really feel bad this alphabetical thing. Maybe we could do it by height or weight or something. I mean, occasionally.
We'll tell Adam to do Z to A sometimes. Well tell him. Your
Member
birthday.
Chaplin's always making seconds. I'm last all the time.
All right. Section D on policy ordinances there. Do we have any comments there? Okay. Anything on E, opinions of the state's attorney? Member to start?
Yeah, I have a real problem with this section, and I hope you guys are on board with me. I feel like we're elected officials, and I believe that any board member should be able to request an opinion from the state's attorney on any issue. I know I've gone to the state's attorney and asked questions on things that I'm working on. And now I see in the rules that I'm not allowed to do that. So unless I'm reading this section completely wrong, I don't think that it says that, I think it says that a board member is not allowed to request an opinion from the state's attorney unless approval by the chairman. So I disagree with this section.
So I think the division line is formal opinion versus opinion, but I want Nick to weigh in and then we can keep discussing.
So that division line is absolutely correct. That's an important distinction here. A formal opinion is a written out opinion that is formally on behalf of our office. It's completely different than you asking us a question. So that's the purpose of this rule, to make sure that anything formally submitted by our office as an opinion is requested by the board and its chairman.
So maybe we should add in here then that any board member can ask an informal opinion of the state's attorney.
Maybe informal advice or something, or seek consultation, maybe that's.
I would say, yeah.
Maybe we can work on the language.
Work on language.
So when it's something more informal, we can work on proposed language for that, so there isn't any misunderstanding.
Yeah, and it doesn't create an obligation for your office. Like that's why we got to be careful there, right? Thank you. I saw member Zay and then member Hart. Oh, no, member Zay.
I agree with member Dessert.
Okay, member Hart.
I'm sorry, could members say repeat that?
I agree with you.
Yeah, my question was more just a question, which was, could the state's attorney give an example of what a formal opinion would relate to, or what it has related to in years past? I know we're delineating between informal and formal, and clearly the rules indicate there's a difference because one says the chairman needs to do. I just like to have that background.
I'm trying to think, it's been a while since we've actually given a formal.
Isn't this one of them, this memo about OMA that Connor's the signatory on it, but it was from December 22nd?
That would not be a formal opinion. The formal opinion is actually issued by the state's attorney.
I feel like there's only been one in the last couple of years and I can't remember the topic.
Oh, perhaps or something. Perhaps, maybe there was one with regard, Cheryl was adding maybe with regard to ETSB. I'm just trying to think of one of the last ones that we've actually done. Sometimes I think we had one with regard to a taxing question for the treasurer. I think that we had one several years back about that. Local, yeah. But generally, those are definitely more formal. They're actually issued by the state's attorney, and that's the difference for the formal opinion versus just, guidance, consultation. I mean, that's given routinely.
Thank you.
Before we move on from this section, is there a case in which you could envision the state's attorney's office not being comfortable giving us advice on a topic? And if so, should that sort of situation be outlined here?
I can't think of anything at this point, but I'll take it back and we can see if there is some type of thing that we generally wouldn't opine on. I honestly can't think of one.
Yeah, I just want to make sure we're not giving you guys some responsibilities to us that you then can't meet. So yeah, just give it some more thought as we keep working here. All right, next item. Oh, sorry, member Say.
Yeah, my only question would be on that. I mean, obviously the state's attorney is the county's attorney. If there was a situation where, say, the sheriff's office is suing the county board, I mean, obviously that would be a situation where he couldn't give us a formal opinion because he's representing both of us. Someone would have to seek outside counsel at that point. I think there's provisions for that, if I'm not mistaken.
Yeah, that makes sense.
So.
Okay.
All right. Next is section F, abstentions due to conflicts of interest. Any items there? All right, we're getting to the last section. It's happening. Section 11, application of county ordinances, resolutions, or policies. Any items there? No? All right. We've gone through our whole rules book. I'm very proud of us. So if we go back to our agenda here, let me pull this up. That completes our items out of discussion. So our next step then, if you remember back to our first meeting, these meetings that we've had now are to get all of our ideas and questions out on the table. Our next meeting will be, we're going to start reviewing the staff report of here's all the questions you asked and here's what we were able to find, with the goal of getting to consensus of a version that we can pass through this committee and then present to our full board. And I think also in the interim, as we're preparing that report, I think it makes sense to ask staff to first focus on getting the public comments issue resolved. So we're figuring out the staffing requirements and needs, how much time that would take. We're talking amongst senior staff and some department heads to figure out where that position should live, and then doing a memo to sort of make sure the whole board agrees and knows what these changes are, how they'll be enforced, and with a start date of, okay, we're starting now. Does everyone agree that that's our most immediate next step while staff is still working on the rest of the report? All right, so Jason, you
muted yourself, Chair Selman.
Yeah, sorry, I don't know how I did that. Do you have concerns about the timeline of being able to get the public comment part resolved in 2 weeks, or do we think that we'll be able to bring that back to this body?
Our next meeting is not until March 16th.
Oh, so plenty of time.
Yeah, so I don't see getting all that public comment stuff together being any issue.
Okay, and then probably even the report. Well, you think we can be able to look at the most?
I would hope to have a full red line version of the county board rules for you with all the comments and such that we've mentioned in these past couple meetings.
Perfect. So that'll be our plan for our next meeting, unless you hear from us and things have gone awry. But I think we're on a good path there. All right. So item 7 here was action items. We don't have any. Yes, remember to start.
I'm sorry, at the end of the rules, I wrote a note to myself that says, go back to page 10, meeting times. Was there something we wanted to revisit about page 10 meeting times? Because I don't recall what it was, but I know that we wanted to go back and talk about this section.
Right. So thank you. The conversation about meeting times was they're too smushed together and this is not working for any of us. We made the decision, I think, that any consolidation of committees would happen in 2022. So I think that the current issue is changing our committees as they are now. I have a meeting with Nick on Friday, and I was going to start talking with him in my vice chair role on talking to the different chairmen of the different committees and stretching things out a little bit. I think the general consensus, and everyone please give me a call if you vehemently disagree, is to try to keep as much as possible on Tuesdays. Intergovernmental, I know, meets on Wednesdays, and there's a couple other committees that already meet on other days, but not to move other committees, just maybe elongate the day. So we'll have more committee meetings in the afternoons, but still give people full time to actually go to their meetings and ask their questions and
would
do
that
business.
22, Madam Chair, or would that happen right away?
We can change the times at any point. So I want to get that done as soon as possible, because I know it's a lot of, your committee I know has had a lot of issues with people running late and then having to leave, and no one wants to do that. We all hate having to be late.
I had to drop out meetings today, 2 committee meetings today, leave early to get to my next meeting. So it would be helpful if we could implement this right away. Thank you.
All right. So when I talk with Nick, I'll get the information I need from him, and I'll be working on this in the next couple of weeks in my vice chair role, not chair of this committee hat. Any other old business? All right. Any new business? All right. Can we get a motion and a second to adjourn, please?
So moved.
Second.
All right. A roll call to adjourn.
Day,
Aye.
Chaplin,
Aye.
Broussard,
Aye.
Eckhoff,
Aye.
Hart,
Aye.
Selman.
Aye. All right. With that, we are adjourned till March 16th. Thank you, everyone. I really could not be more grateful for everyone bringing their absolute A game to this. So thank you. Have a great one.